Thank you. And welcome again to this session. I want to introduce you to Justin Avellar. He is a lawyer who specializes in helping small businesses, nonprofits, and startups with a wide variety of agreements, corporate formation, and corporate governance support. Before starting his own practice, he honed his experience at an international law firm in New York City. He also serves on the board of a nonprofit, Seattle Reconomy, which oversees the Northeast Seattle and Shoreline 2 libraries. With that, Justin, please take over.
Thanks so much, Senya. It's a pleasure to be here today. And my colleague Vivian will be answering any questions you might have in the chat. And I will occasionally look at it as well and try to see if I can tailor anything that is in the presentation a little more to things you're asking about. So feel free to ask questions, whether you can raise your hand or speak up or send it in the chat. Happy to talk to you and try to make this as useful for you as possible. But with that, I'll get this presentation up. Okay. So we're going to start with just some basics about what a contract is and when you might want to think about having a written contract. So at its most basic form, a contract is an agreement between two parties that outline each other's legal obligations. So there's three parts of a contract. There's offer, when you offer somebody, say somebody has a block of wood and you want the block of wood. You offer them $5 for the block of wood. That's the offer. They accept, step two, the offer. Now you have, since you've provided the $5, the consideration, you have a binding contract. So as soon as they accept, you have the money, things can change hands, you have a valid and enforceable agreement. That can be either a written agreement or spoken agreement. So even though handshake deals can be harder to bring to a court, it doesn't mean that they don't exist and they're not enforceable, technically. That being said, about verbal contracts, a written contract is important because it allows you to record their commitment to you and your commitment to them. So people, one, can't back out of it easily, and two, everyone's on the same page. Going back to that initial very basic example, say the other, you think that you in your mind have offered $5 for that piece of wood, and the other person thinks that you offered $7. So when you go to give 5, they said no, you said 7, and there's no piece of paper documenting your agreement that you two have assigned and agreed to. So there's already a conflict because you haven't come to the what's called the meeting of the minds. You don't have the same sort of, you both are on different pages. And this makes it more efficient to have a written agreement, and it makes it more enforceable because it's not he said, or he said, he said. It just going back and forth based on what everyone remembers someone saying in court is, or with whomever. There's an actual written document detailing what you two have agreed to, and of course it's only binding if you two have both agreed to it and signed it and dated it. This the point of contracts is also to make enhance communication and prevent these conflicts from happening later on, because you've both agreed that it's going to be $5 for block wood. And you've discussed this and you've written it down, and the other person's seen what you've written and understands what the offer is and what they're accepting, and can maybe negotiate back with you to make it a higher price, or you can negotiate a lower price, and everyone hopefully or theoretically understands and has communicated successfully. And in signing the agreement, you're reducing the chance of a potential conflict. That's why it would be mitigating risk. Is what a lot of legal work is about, is mitigating risk. Whenever you're considering business partnership, you definitely want to have an agreement. If you are going into business with someone, you want to have maybe, depending on the type of company you're forming, if it's an LLC, you'll want an operating agreement. If if it's a partnership, you'll like an LLP, you'll want a partnership agreement. But if you're already in business, maybe you're just in business on your own, you have your LLC, and you're going to buy, $500, $700, $1,000 of something, you're going to want a written agreement saying that. And that can be simply something that they've provided you, that you've signed, agreed to, that you're going to pay and they're going to deliver these goods. That way you have something written down. That way you have something written down to enforce that rule, that agreement. So Lisa has asked a what an LLP is and what are the advantages versus an LLC. And for most people, an LLC is going to be the best option because it's simpler and easier to use. And the entire company, if used properly, is shielded from liability. An LLP, you can have the partnership, the partners are shielded from the other partner's liability. This is more commonly used for licensed professions like lawyers or doctors. For most businesses, an LLC is definitely the way to go. And yes, it is possible to add members to an LLC. You can bring them on and give them an ownership percentage, a membership, called a membership interest, in really any way you want. They can come in for free. You can make them pay a value that you've determined is equal to the membership interest they're buying. If you already have multiple members in the LLC, you probably will have to get them, depending on your operating agreement, probably have to get them to agree to bring on someone new. But that depends on how you've structured your LLC. Basically, you get someone, you either you're buying in, or the membership interest doesn't have inherent value at that point, so they're just coming on. There's a lot of different ways. So another question says, and we'll get to this one later. We have interns and contractors who remanufacture materials using machinery such as sewing machines, sergers, cutting devices. How can we minimize potential liability in the event of injury? Would written acknowledgement of proper training and acceptance of potential liability cover bases? So we'll go into workplace liability a little bit later on. There's some key contract clauses that, depending on, I mean, if you're just going to Home Depot and buying something, you technically have an agreement to purchase, but you're not going to be having a big contract with them for just buying a vacuum cleaner there, a shop vac or something. But these, if you're developing a contract with someone, you'll definitely want indemnification, which is when one party pays for the other party's liability related to things that the party paying did. So if the party that has to pay, the indemnifying party, violated the contract and caused liability for the other party, caused the other party be sued by someone for maybe failing to meet a deadline, that indemnifying party would have to pay the legal costs and the damages that the indemnified party has to potentially pay for. A force majeure clause is also very useful because it is basically saying if there's an act of God or some big disturbance, whether it's a flood or natural disaster or something else happening, that delays your ability to complete or work on the contract in the way prescribed by the contract, and maybe your deliverables are delayed or the goods are delayed, that you're not liable in that circumstance. Because of that natural disaster, you're not necessarily liable to finish or do whatever it is during that period of time. But once that natural disaster is ended, or whatever it is ended, you have to go back to completing the agreement. You can also write it so the agreement can be terminated by one of the parties in certain circumstances as well. But this gives people a way to not be liable because, not be in trouble because something completely out of their control happened. Limitations of liability is a way to limit how much you could owe the other person if there's the other party suffers a loss. So maybe you don't want to you don't want to be liable for certain consequential things that are beyond the general scope of the agreement, things that happen down the line as sort of a domino effect in relation to what you may or may not have done. And those would be called consequential damages. Those can be limited in this type of section. And that would cut down on your potential liability to the other party because it's not something that you would have necessarily been causing or have done. And these other ones, such as termination, you would want to define how and when you can end the agreement, under what circumstances is generally important, depending on the type of agreement. If one of the parties is basically behaving badly, the other party might want to have the ability to stop the agreement, or you might want to define when the agreement would naturally terminate. And, if it's a certain period of time, the goods have arrived, something's accomplished. This termination section really just defines that. And dispute resolution is a way to set up a structure around how you would resolve disputes if they did arise. And that could be requiring arbitration, requiring mediation first, setting the jurisdiction of where any arbitration, mediation, or litigation would happen, cool down periods, sort of you can set this you can set it so the parties you both have to do certain things and follow certain rules and in if there is a litigation or dispute. And warranties, those are pretty straightforward. You're either warrantying or disclaiming warranties in certain situations. Warranties can apply by law in certain circumstances, especially with goods and consumer goods. And there are times when you would want to either acknowledge the warranty like implied warranties, or disclaim them, or attempt to the uh, best that you can, um, because maybe you don't fall under that situation, or the goods that you're selling are as is, which is you would in that case want to try to disclaim as many warranties as possible. The goods are as is. So we'll move on from contracts now and just give some basic information about reporting requirements for LLCs. Basically, such as in your initial filing, your annual report, getting your EIN, your business license. So for the LLC, your initial filing would be with the Secretary of State's office. It's pretty straightforward. You just would create an account with the Corporations and Charities Division on the Washington Secretary of State website, and then you would follow the instructions for creating a new business and select LLC, and do the initial just follow the prompts, who you want to be, what they call what a member, but what they call governor, and your principal place of business, mailing address, registered agent. Principal place of business has to be a physical location. It can't be a post office box or a post mailbox. It can't be a virtual office unless the virtual office meets certain requirements. It basically is a place that you could go to and you do go to and work out of. But the mailing address can be a PO box or a post mailbox. A registered agent has to be someone or a company that can accept service of process in the state of Washington. The point is to make you suable in the state of Washington if something goes wrong here, that you can't escape the jurisdiction of the state. You basically have to file a report every year saying that your business, whether your business purpose has changed, and what just a couple basic pieces of information like who the members still are, and you have to pay the Secretary of State about $80. You can do that online too. You can paper file it, but it's a lot easier to do it online. You would go to the IRS once you've created your business and then get an EIN. The state identification number, the UBI, the Unified Business Number, is provided to you by the Secretary of State's office when you create a business. The EIN is through the IRS. You can create one very simply through the IRS. You just enter your information and it spits out an EIN. And you will need an EIN before you create a business bank account, which I highly suggest you do. Business license, you will get that either, you definitely will need one through the Department of Revenue, the Washington State Department of Revenue. You also need a city license, business license for whatever city you operate in. So if you are operating potentially with employees in 3 cities, you probably need a license in 3 cities. Don't mess around with it. Just pay the nominal fees and get one. The certain cities allow you to get the license basically through the Department of Revenue when you get your state business license. So those would be, they call those endorsements. The You have to spend a little time playing around with the Department of Revenue's website when you log in, but it'll tell you when you're in the process of creating a business license if you want to add city endorsements. So certain cities, like I believe Bainbridge Island, are using an endorsement on your state business license. The city of Seattle is its own business license that you would have to file annually, and that would be on the File Local website. If you have a C Corp, standard corporation, or an S Corp, these are the reporting requirements are definitely a little more. In addition to having an annual report, you have to have annual meetings for director election and special meetings or resolutions for big decisions. You have to have corporate minutes and things, and you have to do things differently according to bylaws. You would as well for an operating agreement, but it's a little stricter with a corporation. You're taxed when you're taxed as an LLC, you're taxed through your individual income tax. So all the profit and loss comes down to you as an individual. When you're a corporation, you would be filing business income tax with the IRS. So that would be more complicated. And the tax rates are different. The tax, everything about it is generally different from individual income tax. So you're paying yourself, or you're receiving dividends from your company. Everything sits in the company until it is paid out to you or to employees. LLC, everything passes through in the IRS's eyes to the owners, unless it's paid to employees. So now we'll get into a little bit of workplace liability rules. So you have liability, and you have obligations, or what the law you'll hear the word duties to employees and anyone that comes onto the premises. So if you have a business location, or you're using your house, apartment, whatever, and people are coming onto it for your business, you're liable. You owe them an obligation that you're basically going to keep the place in a generally safe and working manner. So if they come in, they're not going to get hurt if they're doing something that you could reasonably expect them to do. If they walk in to your building, they're going to expect that wall of shelves is not going to fall onto them and crush them. They would expect that the floor would be clean and dry unless notified by. That's why you see those sandwich boards that say warning, caution, wet floor, because if they didn't warn you and you slipped, they wouldn't have been providing you that duty of care, and you could sue them for the damages related to your injuries. So make sure that your place is clean, and clean in a way that makes it reasonably safe. You don't want drips that could cause electrical fires or risks. You don't want something that people could slip on. You don't want something that people could that you could foresee someone hurting themselves. with or on or by just the act, by doing something completely normal and having them not expect that risk. If you say, say you have, this is a little bit out there, hypothetical. If you have a room that's filled a wall of knives and they all point out, and you have a big warning on the door that says, warning, wall of pointy knives, and somebody walks in and then they hurt themselves, well, because they run into the wall of knives, then that's maybe a little different. But if somebody's just standing in a clothing store and a knife falls down on their head, now that's very different. You would be failing in your duty of care. The same thing goes for if you're selling goods like furniture or lending things. You owe a duty, and you have an obligation to the person that you're selling something to, that's going to be safe and usable in a way that they would expect. A couch, people expect reasonably that they can sit on it. That's not going to hurt them by sitting on it. It's not going to you know, be, poison them or send off um, toxic gases when they are around it in an abnormal way. All these sorts of things that you would think, you know, you you wouldn't want to happen to you if you just had a couch. Um, the same IKEA, for example, had an issue for a while where their dressers were unstable if the drawers came out a lot, and they would fall over and hurt children. And children also, small children would try to climb them and they would fall over and hurt the children. So they got sued because these were uh, risks that they could easily foresee, and things that people reasonably expected to be safe. They expected the dressers, when the drawers are pulled out, wouldn't fall on them and hurt them. So IKEA now provides you anchors to screw in your dressers to the wall safely, hopefully into the studs. And they provide warnings, multiple warnings on the packaging and I believe in the directions telling you about the risk of injury. So by doing that, they're minimizing their risk and providing a warning that if somebody deals with their furniture incorrectly, they could cause harm to themselves or to other people. So by doing that, they're minimizing the liability. I mean, you can't say, oh, if you have this couch, it might just catch fire, spontaneously, and then you're off the hook. No, the couch is at that point inherently unsafe, and you probably shouldn't be selling it to anyone. If anything, any piece of furniture could spontaneously catch fire, don't sell it. Probably send to hazardous waste site. The same thing goes when you're offering expertise. If you're telling someone how to repair a lamp and your advice is faulty and the lamp catches fire, that's kind of on you. Basically, you owe them an obligation, since you're holding yourself out as an expert in the situation, that they follow your advice and they do it the way you say that it's going to be. They can reasonably expect it's going to be safe. So it's important in these sorts of situations to have a waiver and disclaim any thoughts that you might be that you might be an expert, and refrain from holding yourself out as an expert. Say that you're giving advice, but not claiming you have expertise in the situation. Even if you do, if you're not ready to go there with the expertise, don't hold yourself out as an expert. Uh, basically, yeah, if somebody injures themselves doing self-repair or following self-advice, uh, that you gave as an expert, you could get sued as well. Lisa asks, how would this apply in writing and selling patterns or creating tutorials? Uh, I'm not sure uh, what you mean, Lisa. If you're if you're making a sewing pattern that is going to cause someone to hurt themselves using, I guess that could be a risk. But sewing is not inherently unsafe, and um, you're not helping them build a product that could hurt them. It's probably maybe it's a sweater or something. It's not sweaters are not gonna, they might be itchy, but this wouldn't necessarily be a situation where you have inherent liability risk that I can see off the top of my head. You might want to you definitely would want to think about it for a while to think about any potential way that somebody could hurt themselves using your products. And then think about, is this a reasonable way for somebody to hurt themselves? If they take their hand and stuff it into a sewing machine, that's not reasonable. But if they go light things on a piece of a book on fire and burn themselves, that's not reasonable because that's not its intended use. If the intended use is confusing and people could reasonably think that the intended use was something more dangerous, you could have an issue. But where it's clear that the intended use for the book, if it's a book, the intended use is to read it, then it's generally not you know necessarily an issue. So moving on to occupational health and safety. This is a big topic, only just touching it. It's something that in the resources at the end of the PowerPoint that you'll receive probably later this week or early next week, it will have a little more information from OSHA and from the Washington State Department of Labor and Industries. If you are thinking about having employees or have employees, I strongly suggest that you carefully look into occupational health and safety rules. There are a lot, and that you look into the mandatory signage that you have both for employee rights and employee safety that should be posted in conspicuous places in your place of employment. So anywhere that you would have uh, gathering spot for a break, like a break room, that's where you probably should have all the posters for occupational health and safety and employee rights around minimum wage, anti-harassment, anti-discrimination, those sorts of posters. Employer is responsible for occupational health and safety to keep records of work-related injuries and illnesses. You do not want to try to brush those under the rug. It will come back and bite you. You also are responsible to make the workplace free from serious recognized hazards. There are certain industries that are more inherently dangerous, is more dangerous to work in construction, that is to work desk job, uh, just because of the nature of the work. But even in construction, the companies are required to take certain state and federally mandated risk mitigation measures. So that's why certain places, certain job sites will have netting to prevent workers from falling to their death, things like that. Hard hat requirements, um, tethering requirements. They're also employers are also required to provide safety training in certain situations. Uh, if depending on the type of job and the type of dangers that employees could face. If you are dealing with furniture and old materials that could contain heavy metals such as lead or asbestos, uh, cadmium, other toxic copper, other toxic materials to inhale or ingest, employees need to be alerted and trained on these materials. Well, one, you have to provide an environment that's safe for them to work with these dangerous materials, because ingesting or inhaling these sorts of um, metals and chemicals is very deleterious to people's health, even adults. Lead is unsafe, even for adults. So you have to provide a safe place and safe methods for people to interact with the materials, and safety training on how to do that. It's not enough to give someone a respirator. You have to train them on how to use it and where to do the work in a place that's well ventilated and safe for them to interact with the potentially dangerous materials. So brings right into the next point. You have to provide them PPE when you're exposing workers to hazardous conditions. So it's not what a BYO situation. You have to have workplace requirements for and offer these sorts of things for employee safety. And I would probably mandate it too, that you can't take off your respirator and interact with lead. Um, that would mess up your workers' compensation insurance as well. Just don't do that. They have to keep the PPE on when it's necessary. You also have to use the appropriate color coding and posters and labels, signs to warn of potential hazards. You'll find these on OSHA's website and Department of Labor Industries, what you need to warn about, and whether you need special permission or permits to deal with certain types of materials. The more dangerous it is, the more hazardous it is, the more likely you're going to need special permits and special equipment, maybe such as venting, or you can't do it in certain buildings or around certain neighborhoods, even depending on the toxicity and the hazardousness of the material. So there's a lot to keep in mind. The more dangerous it is, the more you have to keep in mind. The less dangerous the work is, the less you have to keep this sort of occupational and health and safety rules in mind. Don't ignore them, but there'll be less requirements for you. For insurance, you would definitely want, depending if you have a location or people come to your house and you use your house as a business, you're going to want general liability insurance, business liability insurance. That covers things like slip and falls. You're going to want to make sure any coverage you have covers accidents by customers coming in. Your homeowner's insurance isn't going to cover, most likely is not going to cover anything that happens that's related to your business. So if you're having people, if you are driving for Uber and it's your car that you're using, there's a good chance that your regular auto insurance will not cover you unless you have special, if you're in an accident, unless you have specific add-ons or a second policy. If you just have regular, and the same goes if you are having, say, maybe you're selling furniture out of your garage. If you have customers come into your garage, and they hurt themselves, your homeowner's insurance is most likely, and you need to check your policy, but is most likely not going to cover anything that comes out of that. So you would need, again, most likely, or either an add-on from your insurance provider or a second insurance policy that covers any general liability related to your business. And you're also going to want uh, fire and allied lines insurance. This is damages from fire or property, basically inventory, things that you um, like if you have a bunch of furniture um, or a bunch of tools or a bunch of goods, you probably want to insure that because it's going to be quite damaging loss to you financially if you lose it to a fire or theft. These are all things that you would need to make sure are in your policy and at limits that match the risk that you're willing to take and the amount of the value of the goods that you potentially have. If you have a $10,000 policy and $100,000 worth of goods, unless you're willing to risk the $90,000 loss and absorb it, that could be potentially catastrophic. If you have employees, you are probably going to be required by the state and you're going to want to have workers' compensation insurance because it protects the employers and the workers from financial and legal impacts of work-related injuries and occupational diseases. Workers' compensation pays for their workers' approved medical, hospital-related services that are essential to the treatment and recovery related to the workplace accident or injury or issue. The injured worker will also receive partial wage replacements if they're unable to work. And you're basically required to pay into this state insurance plan unless you meet certain exemptions. And you're probably not going to meet the exemptions. And I generally wouldn't try because if you don't do it and you choose to self-insure, you're risking a lot of liability without the insurance plan. This is going to cover potentially catastrophic injuries. So, really bad things can happen to people accidentally, and you just don't want to have to carry that yourself. It could bankrupt you. So there are exceptions, such as if workers are employed to do gardening, maintenance, or repair on an employer's private home. It would be a type of exemption. So, if you have if you're just paying a gardener, you don't need to get workers' compensation insurance. If you and like I said, that there's two ways to do it. You risk yourself, or you pay into the state fund, and the state takes care of it if there's an issue. See what's going on in the chat. Independent contractors are not employees. I got a question saying, are contractors or interns exempt from workers' compensation? As I'll show later, paid interns are considered employees by under state and federal rules. So there's basically, it's just a title difference. You have to pay, you have to consider them as a regular employee, have to pay them minimum wage, and have to meet all the same requirements, legal requirements that you would as an employee. So it's basically making sure that people aren't getting out of treating it out of that they're not just paying their interns $1 an hour or a nominal amount, but making them work as employees. Independent contractors, if as we'll see in just a sec, if they meet the you have to make sure you're not paying someone as an independent contractor that should be an employee. That brings us to the next slide, which basically shows that there's a test that the state has and the federal government has that shows it is sort of a sliding scale where an employee, where it's defined as an employee, where the role is defined as an independent contractor. It's part of it's the one of the factors is the degree of permanence of the work relationship. If you're hiring someone to do a one-off project, then it's less likely that they're an employee in this factor. If you're hiring someone to do stuff for you for years, that's gonna lean towards employee. The degree and nature of control means, are you prescribing the way that they are working, or are they getting to choose the manner and the means to do their work? Are you telling them what time to do the work, or are they giving you a statement of work and then doing it in the time frame that you've agreed upon? The more controlling that you are over their ability to work and the way that they're working, then the more that leans towards being an employee. How integral the work is to your business. Is this an accountant and you're not an accounting firm? You're a furniture repair and resale business. Well, the accountant is not the purpose of the business. So that person is probably, and is almost always, and for small businesses, an independent contractor, because you're hiring an accounting firm or somebody who's an independent accountant. Say you're hiring someone say you have someone who comes around 40 hours a week to refurbish the furniture. That person is much more likely to be an employee because they are working a lot for you, what would be considered full-time, and they're doing something that's absolutely integral to the purpose of the business. So you always have to think, is this position something that is directly related to the purpose of why we exist, or is it secondary to the purpose? It's supportive of the purpose. And you have to have an accountant, or you don't have to, but you would have an accountant to do your books and taxes, but that's not the point of you existing. The same goes for the workers' skill initiative. If you're hiring someone straight out of high school and you are having to train them, then there's that really slides right in over to the employment side. If they're independent contractors, are supposed to be people who are established as businesses. They should have a business license, and they do not need training. They know you're hiring them because of their expertise, their knowledge, and that they're coming in to do the job and not to receive training from you. And the opportunity for financial profit or loss means that they could make money off your agreement or lose money. An employee doesn't really, that's not really a situation for them, basically because they're not their own business. If you people misclassify workers as independent contractors because they don't want to pay the payroll tax, they don't want to pay they don't want to deal with the taxes, federal taxes for employees as well, and they just want to give a 1099 because it's much easier, and then the independent contractor has to deal with paying the taxes themselves. You could be liable in you could be liable for back wages and benefits to anyone, and state and federal fines if you pay someone as an independent contractor that should be an employee. There you might have to pay back taxes and penalties on those back taxes because you've misclassified someone as an employee. You would be violating the rules around filing an I-9, which is determining whether someone can legally work in the United States because you misclassified them as an independent contractor when they should be an employee and you didn't do the required forms. You are potentially violating insurance laws and not providing them so that could be fraud, and you're not providing the independent contractors who should be employees notice obligations and enforcement protections they would normally receive as employees. So, you might know people that do it and are just fine. They've flown under the radar. Don't do it. If it looks like the person should be an employee, you probably need to hire them as an employee. So just have a few minutes left. So we'll run through this quickly. If you're hiring employees, you need to make sure you have a business license first. If you're not licensed with the Department of Revenue, that you got to start there, because you'll need, not only do you need that in order to just conduct business in the state of Washington, you need to have endorsements on your license to allow you to hire employees. Once you do that, and you should do that within 90 days of hiring your first employee. If you know that in, say, 3 months, 3 months, 9 days, but if you're thinking about hiring an employee and going out and doing looking for employees, then you should go now to the Department of Revenue and try to get to add that endorsement. Once you do, you'll get information from the relevant agencies. That'll be the Department of Labor Industries and Employment Security Department in the state of Washington about directions on how to file quarterly wage and hour reports with the state agencies. And you'll get that after registering. If you don't file quarterly, you will potentially be liable for penalties. Make sure you enroll in the unemployment insurance and workers' comp programs. You should receive those, as I said, you should receive that information when you get the state endorsement. And you need to report all new hires to the Department of Social and Health Services within 20 days of hiring someone. And the final thing we're going to talk about quickly is interns. As I said earlier, paid interns must be treated as employees, full stop. If you want an intern that's unpaid, but you want to give them a stipend, the stipend can only be used to cover the reimbursements, basically. So if you're going to give them a gift card, you can give them small gifts, but if you're paying them, then the stipend should be for like the amount of money they have generally spent on transit, or you think they could reasonably be spending on transit, or other related things that they would have to spend in order to be the intern. If you're paying them anything more than that, you have to pay them as an employee. That means adding them in all the places you need to add them and paying them at least minimum wage in the rights, depending on what city it's in, it changes. Seattle is much higher than some other cities in the area. So make sure you are doing it correctly. Unpaid interns, that is also not, you have to be careful with, because the government and the state and federal and local governments do not want basically you to have, a servant, an indentured servant, or, worse. They want to make sure that you're giving someone training, that this is something valuable, as valuable to the intern as it is, and it's not just something that you're taking advantage of somebody. So the government, you can get this from the state of Washington. I believe the Department of Labor and Industries, again, looks at 7 factors to determine if an unpaid intern is properly classified. So you don't need every single one of these. It's sort of a sliding scale, like the employee versus independent contractor. We'll go through them very quickly. The intern employer understand there's no expectation of compensation, because any promise of compensation, explicitly or implied, suggests the intern is employee. So they have to go into it knowing that they're not getting paid, and you don't talk about them getting paid or suggest they would get paid. An internship provides trainings that would be like an educational environment. Intern has to be learning while they're there. They're not just pushing paper, doing, routine, not stuff that a worker would do. They have to be there for an educational reason. The internship is connected with the intern's formal education, such as integrating the job experience with coursework or academic credits. So that's pretty straightforward. Again, you don't have to have all these factors, but you need most of the factors. The internship accommodates the intern's academic commitments by corresponding to the academic calendar. The intern receives beneficial learning throughout the duration of the internship. It goes back to the second point. The intern's work complements instead of displaces the work of paid employees while providing significant educational benefits to the intern. This is not instead of an employee. This is maybe in addition to an employee. The intern and the employer understand the intern is not entitled to a paid job at the end of the internship. The internship is there for a small period of time, or a determined period of time, and then ends. Is not a guarantee they will get employment. And that takes us just past the hour. So I will wrap it up now and see if anyone has any additional questions that they want to shout out.
Now is your last chance to ask questions. Thank you so much, Justin, for this very dense session. A lot of information, and as I mentioned at the beginning of the session, we will provide the recording back to you. Also, as a part of this program, we will provide an opportunity to schedule a free consultation with Justin. I will also follow up with more details in our follow-up email. But other than that, I'm pausing the recording.